The Court of Appeal is the highest level of court in Manitoba. It hears appeals from decisions of judges of the other Manitoba courts. The Court of Appeal also hears appeals from decisions made by many administrative tribunals. Some examples are the Municipal Board, the Social Services Appeal Board, the Automobile Injury Compensation Appeal Commission, the Workers' Compensation Board, and the Human Rights Commission. Not everyone has an automatic right to appeal a decision to the Court of Appeal. Often, permission to appeal is required. This permission is called leave to appeal. Leave to appeal can only be granted by a judge of the Court of Appeal in certain circumstances. Leave to appeal is usually required for a decision of an administrative tribunal. Some court decisions also require leave to appeal. For example, Section 25.2 sub 1 of the Court of Appeal Act requires that you obtain leave to appeal interlocutory decisions in a proceeding. Interlocutory decisions are decisions made during the course of a legal action, but they are not the final decision in the case. They often relate to issues about evidence or procedure. If you want to appeal a decision, you should look at the statute that applies to your case to see what has to be done to appeal it. The statute sets out whether there is a right to appeal and the requirements for leave to appeal. It will also set out a time limit for when you must file the necessary documents in the Court of Appeal. Be careful because this time limit is short. Before a judge of the Court of Appeal can grant you leave to appeal, they will consider 3 factors. The first factor is that the appeal must be about a question of law or jurisdiction. The second factor is that the appeal must have a reasonable chance of success based on the applicable law. The third factor is that the appeal has to be of sufficient importance to be considered by the Court of Appeal. That means that you must explain why the result of the appeal will be important not just for you, but for other people. What is a question of law or jurisdiction can be hard to understand. A question of law means that the appeal has to be about a legal principle. For example, did the tribunal make a mistake by not applying the correct section of the statute? A question of jurisdiction means that the appeal is about whether the decision maker had the authority or right to make the decision. For example, did the tribunal make a mistake by deciding the case in a way not permitted under the statute? It is very difficult to show that an appeal will only be about a question of law or jurisdiction. That is because the decision is usually about what happened, which is the facts. A question about what happened, that is, a question about the facts, is not a question of law or jurisdiction. A judge cannot grant leave to appeal because you say that the tribunal made mistakes about the facts. To start the process for leave to appeal, you must complete a document called a Notice of Motion. This document must be filed in the Court of Appeal Registry Office in the time permitted under the statute, along with the applicable filing fee and a copy of the order and/or decision you wish to appeal. This is an example of a Notice of Motion for leave to appeal. Your completed Notice of Motion should follow this format, but with information specific to your appeal. For example, the title of proceedings should match the order you wish to appeal. If you would like, you can obtain a blank Notice of Motion form from the Court of Appeal Registry Office. Applications for leave to appeal are heard on Thursday mornings at 10 a.m. in either courtroom 330 or 130 of the Winnipeg Law Courts. The Court Registry Office will tell you what dates are available for your hearing so that you can complete your Notice of Motion. You must also file another document called an affidavit. An affidavit is a statement under oath that sets out information and attaches documents about your case. You should attach to the affidavit copies of the order and reasons that you wish to appeal. After you file the Notice of Motion and the affidavit, you must serve them personally on the other parties and the tribunal. You must do this no later than 4 days before the hearing date. There are strict rules for service. They are set out in Court of King's Bench Rule 16, which applies in these circumstances. The Court of King's Bench rules are found in the Court of King's Bench section of the website. To assist the judge, you may also file a document called a motion brief to explain why you think the judge should grant you leave to appeal. It is important for you to comment on the 3 factors that the judge has to consider. You must serve the motion brief on the other parties and the tribunal before the hearing. Prior to the hearing, the judge will review all the documents that you have filed, along with any other documents filed by the other parties. At the hearing, you will also be asked if you want to say anything more about your application. The other parties will also have a chance to speak to the judge. The judge may ask you some questions. The judge will either give the decision right away or will send out a written decision later. A decision that is not given right away is called a reserved decision. You will be contacted by the registry office when the reserved decision is ready for you to pick it up. If you are not granted leave to appeal, the judge may order court costs against you. If you are granted leave to appeal, you will be required to prepare and file more documents for the appeal, which will be heard by 3 judges of the Court of Appeal. The Court of Appeal rules and practice directions set out what is required for the appeal, which can be found on the Manitoba Courts website. The staff at the Court of Appeal Registry Office will be pleased to assist you. However, they cannot provide you with legal advice or help you to fill out forms. Seeking leave to appeal is not easy. To ensure that your rights are protected, legal advice is always recommended.